Fiona Halsey. I've been a lawyer for more than 30 years, and I'm also an ACAMS certified anti-money laundering specialist. We have a small law firm, and we understand the practical challenges that the new AMLCTF requirements will create for smaller firms. This video is part of our AMLCTF Essentials for Lawyers series. It's designed to give you practical and clear guidance in under 7 minutes. Because the videos are short, these are summaries, and you need to carefully consider the law in relation to your own circumstances. Today we're covering what's happening and who will be affected. So I'll just put up the first slide. The changes are that if you provide a designated service from and including 1 July 2026, you must enrol with AUSTRAC. You are then a reporting entity and you have obligations. Those obligations are quite extensive, and this is a whole new regime in terms of how you'll be carrying on practice if you provide designated services. Reporting entities, i.e. if you have enrolled with AUSTRAC, must carry out a risk assessment, develop policies and procedures, undertake client due diligence, train your staff in AMLCTF. You'll need training yourself in AMLCTF, almost certainly. Appoint an AML officer, file suspicious matter reports, arrange an independent review at least once every 3 years, and more. So the big question here for firms will be, are you going to be providing a designated service? And this very busy looking slide sets out designated services. If you'd like to have a look at these yourself, they're in item 6 in section 6 of the AMLCTF Act. These designated services, and this is a broad summary that I've put together, assisting or acting in buying, selling, or otherwise transferring real estate. Assisting or acting in buying, selling, or otherwise transferring or creating or reconstructing a legal entity or legal arrangement. Receiving, holding, or controlling a person's money or other property as part of assisting the person in the planning or execution of a transaction. Acting or arranging for another person to act on behalf of another person as a director or secretary of a company, power of attorney, partner in a partnership, trustee of an express trust or equivalent positions, acting as or arranging for someone to act as a nominee shareholder, or providing a registered office or business address. Now, when you look at these definitions, you will be absolutely, I'm sure that there are just questions just bouncing off in your mind about what all of these will mean. And it's acknowledged by AUSTRAC that there are lots of questions here. And the Law Council's been working hard on attempting to get clarity about what some of these things mean. So what does it mean to be assisting? What will these transactions occur in respect of, for example, selling part of a legal entity? So there's many questions which have not yet been worked out in respect of these. There are some exemptions. The most significant of those is if these services are provided pursuant to a court order. Now, when I say it in that way, what would be, for example, we're assuming that consent orders will be included within this. So if you've got litigation and you've got a settlement, and as part of that settlement arrangement, you've got orders, there would be, for example, a house to be transferred, you would expect the exemption to apply there as we currently know it. So there's still a lot of detail to come about that. Before Christmas, AUSTRAC is going to issue guidance on what is a designated service and provide starter packs. The starter packs are expected to contain guidance and examples as how to undertake the required steps. We are expecting that those starter packs are going to have a lot of material in them to assist you to be able to comply with the requirements by the 1st of July. Most small firms, we feel, will be likely to able to implement these required steps by 1 July 2026. Even if they wait for these starter packs to come out before Christmas, we think that's probably manageable. If you're a property law firm, you're almost certainly caught from everything I've seen in the new regime. so you might want to start a little bit earlier. One other point that we raise is that there's no de minimis exemption so far in respect of these, so that if you are providing any designated services, then you're caught. So something you might want to consider if you're providing those designated services and they're worth less than $25,000 a year to you, I'd be thinking about whether or not you actually want to continue providing those services. The other things that you might care to do at the moment is that you might care to put some money aside in your budget for this, because there will be costs associated. Keep an eye on what's going on with AMLCTF generally. You might enjoy doing some reading on what is money laundering and how does it apply to law firms, because it's quite interesting. And as mentioned, consider, if you've only got a small amount of designated services, I'd be thinking whether you'd continue or not with providing those services, not whether you'd continue as a lawyer or not. And you can see from this slide that you can contact us, and we will enjoy to hear from you. And thanks for watching today. Bye.